So, good morning, everybody. Thank you for being here with us for this so interesting theme. The first and most important thing I have to say is that I am the moderator, so you have to follow my instructions, and that I am not Eduardo Soler. The people who know me, I'm Javier Carvajal. I'm a partner at Herbert Smith Freehills in Spain. And I'm grateful for being the moderator and introducing the panelists today. We're going to talk about litigation funding. You know that litigation funding is a very interesting and popular theme nowadays. It's very useful for complex disputes and litigation. These people have very interesting things to talk about, and we could describe funding litigation with many features. In my personal opinion, I think that funding litigation can be described as a litigation tool which benefits both companies and lawyers. Everybody who's been involved in a complex litigation case knows that complex litigation can be very expensive, and this tool, which is available nowadays nearly all around the world, can help companies and lawyers to get better cases and, to be honest, to earn better fees, and companies because they are able to deal with complex litigation without the financial distress that comes along these types of complex litigations. I'm not going to say any much further. I just wanted to introduce the panelists. We have a twofold profile of speakers. We have lawyers and we have funds. And we're going to talk about the lawyer's perspective and the fund's perspective. I'm not going to introduce the speakers because there's lots of speakers and we don't have much time. But more or less, they're going to speak 5, 6, 7 minutes, each of them. If someone has a question from the floor, please, I encourage you to raise your hand and make the question so that we can make the debate more dynamic. So I'm going to start with Antonio Pastor, who is also not Miguel Riaño, who unfortunately couldn't make it today, and he's going to make the introductory statement as from the lawyer's perspective. So, Antonio.
Is it working? Yeah. Well, it's my pleasure and my honor to be here with you. Thank you for having me. I promise not to speak for more than 5 minutes due to the number of speakers. And the first thing I want to say is that my law firm has got a great deal of experience in litigation funding, not only in the Madrid office, but also across the world. We understand this is an essential resource of the justice system perceived to be in the public interest. And I say the public interest because it is important that all enterprises and group claimants are able to access justice, which is the title of this panel. Litigation finance has become a kind of a global industry due to the increasing size and complexity of disputes. In fact, clients are often faced with an immediate need for resources, and proceedings may take long to resolve. Courts increasingly accept funding arrangements as promoting access to justice. And it is worth noting that funding investor-state dispute settlement claims is on the rise. Well, this is not the panel for protection of investment, but cost and duration are one of the outstanding concerns in the works of the ancestral working group carrying out the reform of the investment arbitration mechanisms. Moreover, in practice, states enact legislation permitting third-party funding for international arbitration cases, including the enforcement of arbitral awards. Some national legislation addresses concerns in relation to issues of confidentiality, privacy, privilege, and conflict of interests. In Spain, funding litigation is also let's say, a developing area. I think we are moving in the right direction. And I want to stress this idea. Law firms must take special care to refer to funders good quality cases. The cases have to be skillfully presented, identifying the key issues related to merits, quantum, and enforceability, compiling relevant documents and providing the details which are needed to make an informed decision by the funder. We must give the funder let's say, a clear idea of the chances of success. Obviously, it is up to the funder to conduct thorough due diligence. And finally, and this will be my last idea, and I'll be done, the appetite for the use of third-party funding across the world and the benefits for the claimants are bringing many countries into the fold. Thank you.
Thank you, Antonio. I agree with you. There's an appetite in Spain, a growing appetite in Spain for funding litigation. In our firm, we're starting to work with funds. And I also agree with something that Antonio has said. Not all disputes are fit for funding litigation. I think this is something which we have to stress. Not every single lawsuit is fit for funding litigation. In principle, only complex disputes. And I think that we can can introduce James Blake. James is a US lawyer. In the US, funding litigation has a more traditional track record than in Spain, so we'll be happy to hear your views on this matter. Thank you, James.
Thank you. Thank you. Good morning. It's a great pleasure to be here today. I'm probably going to take more of a contra view. I've spent most of my career as a general counsel and a corporate counsel on the receiving side of these lawsuits. So I think I may have a slightly different perspective than some of my colleagues who represent plaintiffs and who represent the funds. There was just a poll recently, and 3/4 of law firms are saying that litigation funding is becoming more and more an important part of their practice, and 70% of those that have used it have said they will use it again. So it is certainly growing, but I think I would take the position that just because it's getting bigger and growing doesn't make it necessarily a good thing. So here's a couple of concerns from the defense side I would just want to take a couple of moments about. One of our biggest concerns, and I'm sure this will be addressed by my colleagues, is the funds stay out. They don't get involved in the strategy. They don't get involved in the tactics. They're just like insurance companies on the other side. Well, as a defense, on the defense side, and we have insurance covering some of our claims. I have to tell you that we're constantly on the phone with the insurance company, and they're asking us this question and that question, the other question about how's it going, and it's more than just, well, tell me the outcome. So there is a concern, I think, that funds can become a greater influence in the litigation and the substance of the litigation. There are those people who would already complain that many of these class action suits are, as we call them in English, plaintiffless, without plaintiffs. That in many cases, in most cases, plaintiffs find lawyers. One of the complaints about class actions is that lawyers find plaintiffs. Now, we could talk about the merits of class actions. That's a different panel. I don't want to get into that. But I just think that litigation funding does add another layer of complexity about who's driving, as we say in English, this train, and who's making the money and who's making the profits. And also some of these funders have come under scrutiny already in the United States. In 2017, our Consumer Financial Board and the New York Attorney General have brought cases against some of these funders for questions of deceptive practices, issues of high interest rates. The case was thrown out only because the government entity that brought it was deemed to be an unconstitutional entity. They never got to the merits of the case. So that's still up, and I still think many very much up in the air. And again, I would question, or at least want to ask about, yes, the funders say, well, we don't get involved directly, but if you, as a lawyer, and I know who's behind and funding what I'm doing, if I'm on the defense side, it's always in my mind. I'm always wondering, what will the funder want? If I do this case right, will the funder work with me again? And I think that those become sort of more silent or more quiet influences, and I'm just not sure, obviously, considering what my colleagues say, is that really benefiting and helping litigation? Another point is in some jurisdictions, they only allow single case funding, that a funder will fund a case on its merits. There are other jurisdictions in the U.S. that are allowing what we call portfolio funding, which raises a whole other set of issues on our side. Because a funder, as an investor's not going to invest in a bad stock. As a funder is not going to invest in a bad lawsuit, or a lawsuit that's probably not going to win. But if we now have portfolio funding, what that now does is says, well, you know, we'll take a little good and we'll take a little bad. So instead of investing in a single stock, I'm investing in a whole family of stocks, or I'm investing in a whole family of cases, which encourages, again, from a defendant's perspective, some cases that probably would not otherwise be brought, but because we have a portfolio funding and we can spread the costs across many lawsuits, a case that would otherwise not be brought, a case that would be marginal, or dare I say improper, could be brought under portfolio funding. So I think that's another concern that definitely has to be looked at. And I'll try to stay under 5 minutes. The last part I want to talk about is disclosure and transparency. I think we all believe in transparency. We all believe in disclosure. It's very, very, very important. But one of the questions has become is it fair that the plaintiffs and plaintiffs' counsel have to disclose whether they're working with a funder or not, and how much the funder is donating, and what's the financial arrangement? At least in the U.S., it is mandatory under the federal rules of evidence in our federal courts, and also in most of our states, that if a defendant has insurance, they must disclose the insurer, and they must disclose the limitations on their insurance policy. In many cases, what that does, it actually causes settlement relatively quickly, because a judge who has, in their view, better things to do than this case will sit down with the two lawyers and say, okay, what's the insurance coverage? X, good, you're settling for X today, next case. Now, I think if it's fair and it's required that the defendants have to disclose that, I would suggest that it's only fair also that the plaintiffs have to disclose that. How much is the fund invested in this matter? Because when settlement is being discussed, and most of these cases don't go to trial, they do settle, I think it's important to understand and to know what is the funder looking to get out of this. How much is the funder invested? Because in many of these cases, the funder does take their investment back and then a percentage of the recovery. A fair arrangement if everybody understands it and works in with those parameters. But again, I think it's unfair if the defense has to disclose what their limitations are financially, but not necessarily on the plaintiff's side. So my point would be, if we're going to have disclosures, especially if we're going to be doing portfolio funding, that we really do need to have full disclosure across the board. And just one quick in conclusion, as I say, this is very game-changing. It's growing very quickly in the United States. It did start in the UK and Australia. I see it growing across Europe and Asia and other jurisdictions. On behalf of the defendants, the bigger corporations and small corporations who are going to be subject to these things, we just want to make sure that as the game progresses, that the game is fair and the game is transparent, and not, as we might say in English, that the game is rigged. I thank you all for your time. I look forward to hearing from the rest of my colleagues.
Thank you, James. Interesting points from a U.S. perspective. I think it would be interesting to know Eric's point of view, especially because James mentioned some points regarding disclosure. As you may know, the European common law countries have different rules. Disclosure requirements are much less stricter than in the US and England, for example. So interesting to see what Eric has to say about
But it's
this
coming.
and another points.
It's coming, I think. So since my name is Eric, Eric Breiteneder. I'm a lawyer based in Vienna. Our firm is doing collective redress. We are involved in cases like VW or foreign exchange manipulation or drug cartel. So 5-6 years ago, I did not even know what that means, being involved in collective redress, because we started as a plaintiff law firms with individual claims, going to court, being disappointed because when you're attacking big corporations, and you are close that your judge is making a decision, they simply pay you out. So a class like the US lawyers would like to say, it was very difficult. So I can say I'm through everything with what is on funding side. We collected amounts of money from a group of plaintiffs. We had private funders, and we had lately professional litigation funders. So the issue is that in Europe, in most of the jurisdictions, they are based by the principles loser takes it principle, which means if you lose the case as a plaintiff, you have to refund the costs of the defending party, which can be very expensive when you are litigating in the UK, which is regulated in jurisdictions like Austria. In Germany, you have caps, so you know exactly in the beginning what the risk funding a case will be. I think this is key for funders who are entering the scene in Europe, because it's a diversity of different regulations, how third-party funding is accepted in a case. What James said is true. Once you have a funding in place, defendants do a lot to figure out what's in your pockets, because simply it's the price tag that you put, especially on a case of collective redress. To have a claim and to get the defending party paying for your claim are two different things. So having this panel on the World Law Congress and having in mind that the World Jurist Organization has its credo in peaceful law, I think third-party funders, and I think they should be aware of that role, having an important role in Europe. They are filling a gap. They are filling a gap for groups of plaintiffs accessing and hopefully getting a fair trial. Because without funding, you can't litigate in most of our jurisdictions. I think, and this is what I wanted to address to the funders in our group. There are so many third-party funders out there. Europe is a market for them, which is exploding at the moment. The rates for third-party funders vary from jurisdiction to jurisdiction and depend on the risk that the funder takes over. But merely they are between 20% and 35%, in some cases 40%, on the share, as a share of a possible outcome. So that is a lot of money. It's a lot of risk that funders are taking over. So, but it's a chance for them. What we experienced lately, and this is what I wanted to address to the funders, is defendants are bringing in court the question like, if you're representing a group or a class in a collective action, they try to challenge to figure out, and that I completely agree with James, what's in your pockets. So lately, some procedures, especially in Germany, were held because the defendants are questioning if plaintiffs can afford to do the court procedure and lose it. And if they are not, and if they are not bringing proper evidences how much is in your pocket, or you give the court the comfort that the organization who is sometimes in the plaintiff role can afford defendant costs. It simply causes delays in procedures. And that's what defendants are trying to do in Europe. They simply try to delay every procedure until a statute of limitation simply kill the majority of a claim. So how can funders secure lawyers and the plaintiffs and organization on plaintiff side to give more comfort that these objections of defendants are not seen as such an obstacle for the procedures. So what we experienced are bank guarantees. That's one thing, which are costly. The other thing is that organizations are simply funded with a cash amount that you can present to courts. So the big question always in Europe compared to the US is, are you regulating third-party funding or do you leave it to the market to develop rulings, what's fair and what's unfair? I know that we have Kalunius on the panel and we have Therium. I know that they are members of the Association for Litigation Funding, which is, so far as I know, a starting point for giving compliance rules on litigation funding. And in my opinion, that's the right way forward. Thank you.
Thank you very much. I agree with you. I think I would highlight two things that you've said. One is litigation is different depending on the country where you litigate. It's not the same litigate in Austria, in the US, or even Spain. The rules are different. So, and litigation funds have to adapt to their jurisdiction where they are going to be involved. And the other one is going back to what Antonio Pastor said before. Litigation funding is also a tool for giving access, justice access to people or to companies that, under normal circumstances, wouldn't have this ability to bring proceedings because of high financial stress this comes along with. Let's go back to the U.S. David, let's see if you agree with what we've said up to now.
Good morning. David Covell. I'm a managing partner at Kirby McInerney, which is a boutique law firm in New York, and in California we specialize in financial cases. We're primarily a contingency fee law firm that works on behalf of classes or individuals for financial frauds, and we work entirely or almost entirely on contingency fees. And I think that's important because the U.S. has a bit more developed set of rules when it comes to how to fund cases. And when you think about litigation funding, in some respects it's been around for a very long time in the United States because in the US lawyers are allowed to work on a contingency fee basis, right? What's a contingency fee basis? If a claimant comes to me, I can take on the case without charging them anything except for a percentage of whatever they recover, or I recover for them at the end of the case.
So it's a full success fee.
Full success fee, and that's legal in the United States. It's not legal in it's not allowed in other jurisdictions. Sometimes there's hybrids, but in the U.S. it's been allowed for a very long time. So firms like mine, which are contingency fee firms, have developed, and we've developed in a way that is essentially a litigation funding model. We have capitalized ourselves and we invest in cases. In some ways you can think of it as venture capital. We invest in a portfolio of cases, and that portfolio may return at different times over the course of many, many different cases. So they're lumpy returns. Sometimes they're very good, sometimes they're not, and they're unpredictable returns. But it's been a model that's been around. It's a litigation funding model that is well known, and it does, and I totally agree with the sentiment, allow for cases that would not have the wherewithal, people who don't have the money to proceed, or classes where there aren't huge losses, but there are losses across the class. Those can proceed when there's a contingency fee aspect to this. Now, over the last 10 years, litigation funding has exploded in the United States as well. And how has that changed? Well, from the contingency fee perspective in the United States, in some ways it hasn't changed anything. It's sort of just changed who's providing the capital. So a firm like mine, or a firm that's getting started that wants to be like mine, which isn't that well capitalized, will use litigation funding, and that will allow them to amplify their resources. In some respects, too, it will allow law firms that don't like to charge contingency fees, don't like to take that risk. It'll allow them to bring a case in a model that would allow them to make money, and it's the funder that takes the risk on the contingency fee. How does the litigation funder in a contingency fee model in the United States invest? Well, I'll leave probably the gory details to the funding folks on the panel, but in a general sense, I've seen a couple of different ways it can be done. One is the funder will go straight to the plaintiff, the claimant, and provide them with money, and that money will maybe fund their life if they're a whistleblower saying they've been put out of business, or if for other reasons they can't make money, it'll fund their life, and it may also fund the law firm, right? It will pay the bills of the law firm. That's one way, and then the funder will take a return at the back end if there's a success. Another way is this portfolio funding that Mr. Black doesn't see as a good model. Portfolio funding is when you have a basket of cases and a lit funder will give you some money for that upfront or over a continualized period for that basket as those cases mature and pay for the expenses. And they take a pretty penny on the back end, by the way. So from my perspective as a contingency fee lawyer, I go to litigation funders with reluctance. I would rather fund my own cases. But they do that. I also go to banks. So a bank will provide a line of credit to my firm for all of my cases. And based on the assets that they see for the contingency fee cases, I don't really see a distinction between a portfolio funding from a lit funder and a line of credit from an established bank. They actually function in the same way. From a tax perspective, there are different advantages or disadvantages, but they act in the same way.
A bank may fund your business, and a litigation fund funds a case.
Right, but if we're talking about portfolio funding, the line is very blurred, right? If the portfolio funder is funding 20 of your cases, maybe that's 50% of your portfolio, your business. Yeah. Well, what does a bank look at? A bank looks at all of your cases and then gives you a line of credit. It's a very similar kind of analysis. I also, just to address a couple of things that Mr. Black said, in my experience, litigation funders have no say in how a case is prosecuted, and don't even try to get involved. It just isn't. I don't see that as I see it as a boogeyman. I don't see that as a real problem, at least from my perspective. There may be others in the United States who've had other experiences. I also know that in class action litigation, where there's a whole class, the U.S. court system is designed so that the judge overseeing the case has some responsibility for making sure the class is looked after, as well as the lawyers. Lawyers have a fiduciary duty, class representatives have a fiduciary duty, but the judges have taken, with this new advent of litigation funding, have taken a perspective that they need to know what the incentives are for lawyers. So they do require, Mr. Black, they do require disclosure generally. They don't require the plaintiff's lawyers or the plaintiffs to give that disclosure to the defendant, but they look at it in camera. The judges will look at the funding to make sure that it's a proper funding, that it's not providing perverse incentives, whatever those might be, and generally they tolerate this. It's not been something that's been a problem as long as it's disclosed. I can end there, or I can keep talking, but I'll end there.
Thank you very much. Very interesting points. Geneviève, your turn. I think you're going to talk about a very interesting point, which is the legal in-house perspective. If the mic works.
Yeah, is it working? Yeah.
No, I don't think so.
Bad luck. So, hello, my name is, It is working now. Hello, my name is Geneviève. I've been asked today to talk about the in-house perspective, but as well about the evaluation of third-party funding over the years. I've been my side of in the both side of the fence. I've been first as a funder for 10 years, and now I'm back in as a lawyer in a claimant plaintiff firm, U.S. claimant plaintiff firm. So what I can say is that the third-party funding market has dramatically changed over the years. You know, in England, for example, we had the Jackson reform in 2009. We had a new regulation as well in 2013 about damage-based agreement, which changed as well the position of the lawyer and the claimant and the funder dramatically. And now we have a revision of the legal aid in England, who's going to bring as well a review of the rules in third-party funding and CFAs and on the damage-based agreement. So although as a lawyer in England, we have under the SRA rule the obligation to inform our client about the different funding available, the different option of funding available. I can say that this obligations has changed a lot over the years, as our relationship now with funder is a little bit more balanced. When I started in the funding industry in 2009, we had to inform our client that a funder, funding option may be available for them, but the funder will take something like 40% of the damages, or it will take a multiple. For example, it will take 6 times the amount of his investment if the case is successful. So, which was quite a lot. But now, what we have begun to see in the market, especially in Europe, we have offering, we have been offering as a lawyer by a third-party funder in Europe at least to have our fees paid, 100% of our fees or 70% of our fees, and as well they're offering us to split their share of recovery. For example, they will do an amount of money, they will pay 70% of our fees, and after that, after they recover their money, we'll have a split of the recovery in waterfall. So obviously, this changed dramatically the dynamic as a lawyer, and we feel more comfortable now as well to talk about the funding option available with our client. Just to answer maybe to response of James Black's comment, in-house lawyer as a big corporation, of course, maybe third-party funding may be a problem when you are on the defense side, but some of the big corporate have now seen funding as a way to transform their legal department in a profit center. For example, in the area of competition law, we have now a big multinational company who have decided to go against the cartelists, following damages actions, as we call, and to use funding. So basically, they have a decision of the commission, so they have decided now to use third-party funding to recover their part of the money. So they use third-party funding to split the risk, to don't have upfront costs. They go against the carteliers, they recover money, and basically they transform their department on a profit center. We begin to see that more and more. So it's a different perception as well for in-house lawyer, and they begin generally to see third-party funding as a way, to progress and to move forward positively with the flow. So I think, I will do a bold statement here for the third-party funding panel. I think only funders who will adapt themselves to the new reality, that's meant to be more flexible in their offering of funding, in their term, will survive. Because I think now the relationship have changed. As a lawyer, we have the possibility with our client, and I don't like the term shopping, but to shop around and to see what is the best available funding option on the market. So, and just as well to answer to Jack, to James, sorry. I know that, a lot of third-party funders are not getting involved in the litigation, but for example, in Australia, a third-party funder can be involved in the litigation as a funder. They have, since 2006, the possibility to give instruction directly to the lawyer. So that's made the position a little bit different as well as a funder. Of course, in England, we have the Association of Litigation Funder, who has regulation, but is a self-regulation, who basically, you're not allowed to be involved in the case, but, some funder are not part of this Association of Litigation Funder, and they take an approach a little bit more proactive, and I don't think as a lawyer that's is definitely a problem, because you have two sides, two perception on a case, and at the end of the day, as a lawyer, your client remain your client. Your client's never going to be the third-party funder, so you have some rules to follow as a lawyer, as we all know. So I don't think it's a problem. So yeah. So
Thank you very much. I think that's a very interesting point. The perspective of funding litigation for companies, which is let's transform into a cost profit center rather than a cost center, which is something which is really important for in-house lawyers, which are always seen as cost centers, and internally it's a burden for them. So I think it's a very interesting point. To finish with the lawyer's perspectives, we have Philip, which is based in the UK, most traditional jurisdiction for funding litigation, maybe.
Certainly, excuse me. Certainly within Europe. Philip Rubins. I'm a partner in a London law firm called Teacher Stern. I spend a substantial amount of my time with plaintiffs and in discussion with litigation funders. I wish it was all so simple. I'm afraid it's not. I don't know the Spanish translation for a walk in the park, but to obtain litigation funding...
Un paseo.
Oh, right. I bow to your...
It's not like walking Miss Daisy.
I see. Well, my perspective is that it certainly is not a walk in the park to obtain litigation funding. By way of contrast, if you read a lot of the legal press, you'll see there are a huge number of funders, new funders, coming out the whole time. Funders are awash with money, looking for suitable cases to spend their money on, which may all be very true indeed. And certain funders will prefer maybe an arbitration or an ICSID, an investment treaty arbitration. Some will prefer commercial litigation. And indeed, one major funder that I've come across has said that they've actually never won an arbitration case at all, which is rather depressing for them and for their investors. Certainly, I know of a fund that was set up about 3 years ago. They've looked at over 200 cases, and I think they've funded 3 or 4. And that may be fairly consistent with the reality of the situation that a claimant lawyer will face. We know in reality that the funders are only going to fund cases that meet their criteria, which is a strong view on the merits of the case, and also the ability to enforce any judgment which may be obtained. And certainly I see cases on a weekly or bi-weekly basis. Clients are saying to me, well, can you get funding, or can we get funding on this particular case? And if the merits are not substantially in favor of the claimant, then it's just not worthwhile even putting it under the funder's nose. It's a complete waste of time. You'll just never get the funding if one thinks it through, and that there's funding only maybe for 5% of all cases that are put to a funder. It may not be exactly 5%, but it is a very small minority of cases that you will obtain funding for. The due diligence process that one has to undertake can, in my experience, last several months. An enormous amount of questions that the funder will put forward. It then has to go to, and even if you get through all of that, it then has to go to the funder's investment committee, and they may come back with more questions as well. Even if you get through that, I've had a situation where the funder said, well, we actually want to interview your main witness. We want to see what he's actually like as an individual and how he is going to address issues such as cross-examination. And if you want to do business with them, you've got no choice. So the funder will interview alone a witness from time to time. And this whole due diligence process can take many months indeed, and at a substantial cost. Well, again, who's going to pay for that cost? Because most funders certainly are not prepared to pay for funding before you've actually signed off an investment agreement. It might then give you some form of partial reimbursement for some of the costs that you've incurred. But if some in the audience think that it's just a small number of questions that the funder's got, this could all be done with a small number of weeks at a minimal cost, certainly on cases, significant cases, it just isn't going to happen. So I think it's important to bear in mind, and we'll hear from funders, but from my experience as a claimant lawyer, and certainly in terms of complexity, the last thing that a funder wants is such a complex case that they can't work out the true merits. And certainly if you turn around to a funder and say to them that there are a substantial number of unknowns, he or she will come back to you and say, well, call me in 6 months' time when you've worked it all out. But you're never going to get funding, certainly in London from my experience, if there are a substantial number of unknowns. A funder expects you to be able to present a case which sets out the merits, limits the amount of unknowns, and makes it possible for the enforcement of a judgment. One final point on costs. In general terms, funders will want you to produce a budget fairly early on and are looking for a return of maybe 10 to 1. So if a case has a realistic damages expectation of £10 million, most funders will say that your budget, including all expert evidence, maybe counsel in the UK, independent counsel, cannot exceed 1 million. So it's a 10 to 1 type of a ratio. There is some flexibility there, but if you've got a case that with a damages estimate of £10 million and you turn around to a funder and say it's going to cost between 3 and 4, I think you'll have a very short conversation indeed. Thank you.
Thank you. Thank you, Philip. That's the downside of funding litigation. Obviously, funds are not charities, but we'll give the opportunity to the funds to give their perspective. And I just wanted to highlight something that Philip just mentioned, which is the scope of the funding. Normally, funds don't fund until the outcome of the arbitration or the lawsuit. They also sometimes fund until the enforcement phase, until money is effectively collected. But I'm not going to take away the possibility for the funds to explain this. Eduardo is still a lawyer, but if you don't mind, Eduardo, I'll leave you till the end, okay? And let's give the opportunity to funds to give their statements. Diego, should we start with you?
I feel very protected behind you,
Okay.
so don't worry, don't move away. Yeah, don't worry, no, I'm well here. Okay, my name is Diego Santa Cruz. I am the director of Carbonia Investment. Most of you would ask yourself, what's Carbonia Investment? And I'm happy to introduce Carbonia Investment as Spanish litigation fund. I believe that this is the first, I'm not mistaken if I said that this is the first litigation fund, Spanish litigation fund. Sorry. I have a strong voice, so I maybe don't need it. Okay. It's okay? Okay. So I was saying that I'm not mistaken if I said that Carbonia is the first Spanish litigation fund. However, I'm here to explain you our experience regarding the management and launching of this litigation fund. In this regard, when we have to deal with the management of a litigation fund, we have to take into account several ideas that are basically the following. Firstly, it's very important to be flexible. Our clients have different necessities, they pursue different objectives. So we shall be able to provide our clients with a measure-made approach for every of their cases. In this regard, we also need to be flexible and adapt our structure to our clients' necessity. Secondly, we have to take into account that we have to deal with different kinds of proceedings. We are talking about proceedings subject to different laws and different jurisdictions. We may be talking about a portfolio of claims that are under different jurisdiction, European, American jurisdiction, and subject to different laws. We are talking about jurisdictional claims. We are talking about an arbitration claims. So the team has to be a strong legal team. Thirdly, and this is very important, and I would like to highlight this idea, as a fund, we are not just an information recollector. We don't just collect information. We obviously have to collect information from all the proceedings, but it's more important for us and for our client to analyze that information, and once we have analyzed that information, to provide our client with a strategic analysis of the outcome of the proceedings. Our client wants to know how the proceeding is going to finish and what is happening in that proceeding. In this regard, it's vital for us to enjoy with a strong electronic platform that help us to analyze that information. So those are the basic principles under which we have built Carbonia. This is a great experience, and I think it will have a great future. Thank you.
Thank you, Diego. Very interesting. I think that from what Diego has just mentioned, funding litigation is not a commodity. Obviously, funds carry out a tailor-made process. So each case it has its own features. Each case is going to be dealt with in a different jurisdiction with different rules, different seats, different applicable laws. So funds have to adapt to the specific case. So forget about commodities. This is a tailor-made process, and that's why, going back to what Philip said, it's a long process. Okay, great. Ignacio, your turn.
Good morning. Good morning. First of all, thank you very much for the invitation. It's a great pleasure and honor to be here this morning. I would like to take just a couple of thoughts I have been thinking of during the whole panel, and I think that it could be quite interesting to analyze them, because they are the main concerns of the lawyers involved in third-party funding or litigation funding, so they should be our main concerns as well. I really think, like Antonio Pastor said before, that litigation funding is just a tool, and this is how I always have seen and thought about our task in all this role. We should be just a tool, and this is why we should adapt ourselves to the needs of the market. We should be in every single jurisdiction following what the law firms are looking for, what our clients are looking for, and try to support them and to go together with them, and always to be in the same page. We have to have all our interests aligned always. This is our main purpose, and this is why, for example, here in Spain, no matter if we have been less than 3 years, and we have already analyzed more than 100 opportunities, we have always been trying to adapt ourselves to what the market needs from us. And this means, for example, that we started with the main core business, like in other jurisdictions, analyzing one-off deals, individual litigation funding agreements, in single deals, and we move forward very quickly to portfolio funding, and this means not only portfolio funding within the same law firm in the same area, but also we have been analyzing very close with law firms to fund the law firms. And maybe this is very similar to what in the States you have seen until now. Here in Spain, of course, as everybody may know, massive litigation has been suffering an explosion in the last years, and we have been inquired to help some of these law firms with the working capital, just taking as a collateral the success fee basis they are working for, or they are looking for at the end of the day, and this is something we can do in addition to the traditional litigation funding. We have been moving forward as well to a new market, which is the acquisition of portfolios for the companies, where the companies are selling, basically, just to make a basic idea of what this means. This should be companies selling their entire portfolio of claims, so they can make an upfront payment, which is something that they can put in their P&L as an income. So this is very helpful for some of them for many reasons, and in abroad in several opportunities. It doesn't matter if the company if in bankruptcy, or maybe they just want to share some profit with their shareholders. So there's a lot of different scenarios where you can see these kind of opportunities. And I want to be brief because I think that the most important thing is to hear what are the questions of the audience, and I will be glad to answer whatever it is raised. But just to highlight that we really would like to adapt ourselves to the changes of the market. We are really trying to to accept all these challenges of every single jurisdiction we are working in, and we will try to adapt ourselves to what is inquired by this industry. Thank you very much.
Thank you, Ignacio. I think it's very interesting things. To highlight what you've mentioned, the legal market, the legal profession is changing very fast. It's very challenging. At least from a Spanish perspective, full contingency fees were banned in Spain until 10 years ago. So full access fees we couldn't structure our fees on that basis. Now we can. There are new legal firms that only work with full success fees in Spain. So as Ignacio was saying, we have to adapt. We have to take tailor-made approaches to cases, and this is very interesting. And if we're going to Antonio, I would like to ask a question. From the fund's perspective, is it true that you don't only fund poor companies that cannot earn, don't have the possibility to structure to finance their own litigations? Is it true that you also fund wealthy companies that just don't want to have the litigation portfolio and they just want to take it out of their P&L and get on with their business? Is this correct?
Thank you, Javier. It's a quite tough question. It might be true that in the origins of litigation funding, the classic case was the David versus Goliath case, in which David had almost nothing to do against Goliath and came to us, to funders, to try to equalize firepower among the parties. But that was pretty much in the origin of this industry. We still see that kind of cases quite a lot, but I wouldn't say that's a majority of the transactions in which we are involved. Our industry nowadays is pretty much about managing risks, managing litigation risks, and I would also try to take a step backwards to try to expose some of the things that are on the funder's mind when it is approached by claimants, lawyers, or whomever. In our industry, well, we at least in Colonials are pretty much focused on commercial litigation and arbitration. So that's only one part of justice. Justice is not always about money and big corporates fighting each other. Justice is about some other things. We're not usually involved in those other aspects. We're focused on commercial arbitrations, commercial disputes. For us, and as in any other area of the economy, assets have a value. In some cases, or in most cases, the value of an asset is pretty hard to tell what it is. How much is Apple worth? Well, you can go to the stock market and see what the market thinks about Apple's worth. But how much is a non-listed company worth? Nobody knows, or some people know. That's probably a question for private equity firms or hedge funds who are devoted to price and fund or finance that kind of assets. We as funders are devoted to legal assets. Legal assets are simply assets, rights, whose value is locked by a legal dispute or some sort of discussion. But no matter that, we still see that as an asset. We believe in the value hidden by the discussion, and we praise ourselves to be experts on identifying and pricing those assets. So when pricing those assets, everybody, lawyers and claimants, should have in mind that that's our task, that's our role, and that's all we want. Concerns such as control. Well, as all my colleagues said, control depends a lot on in which jurisdiction the transaction is happening. For us, and also for Therium, as members of the Association of Litigation Funders in England and Wales, we don't see control. In all honesty, we're not really interested in control as long as it doesn't have a direct and real impact on the value of the asset. We trust lawyers. In Spain, a lot of law firms with whom we've worked before are pretty surprised to see how much we trust their criteria and their knowledge. We don't seek to retain controlled rights. We do seek some protections, but those protections are usually aimed to ensure that the game is fair, that our investment is based on fair information, and that the claimant itself won't have any negative incentives to affect the value of the asset in which we have invested. Because to some extent, we turn ourselves into partners for the claimants, and we just want a fair treatment among partners. That's all we want. We're not guided by an irrational wish to keep secret our deals with claimants. We're pretty much willing to disclose whatever is needed for protecting the litigation, the rules which will ultimately unlock the value of the assets in which we have invested. We are not guided by any kind of secret or hidden interest. It's plain simple. It's the interest of the claimant also. We are sharing the value of an asset, that's all. I could still talk a little bit more, but I think I'm going to stop over here.
Okay. Simon, this is Simon works at is in the fund side, based in
insurance.
Exactly in the from an English perspective, and he has the difficult task of underwriting, which is also very difficult. How many questions do you raise to the client when doing the underwriting?
Philip will probably tell me I do more than this, but it depends on the case presentation, and I think that was something that was picked up on earlier. A properly presented case, or a very well presented case, will kind of raise very few questions.
Yeah.
I mean, I was going to start by replying to a point Eric made earlier, which is regarding security for costs. And of course, I would say this, but the answer to that is generally insurance.
Yeah.
Although that does have its limitations, and it takes the game of security to another stage, which can be dealt with, but it is part of the process on certain litigation in order to try and smother the litigation by running security actions. Just to give a brief bit of background, so I'm talking on the funder panel, but I work for AmTrust, and we're an insurer. So we insure funders' exposures to adverse costs, and we also insure a lot of legal expenses policies that provide another sort of litigation funding, i.e. that where the policy will pay the cost of litigation. I think it's important to think litigation funding, which is all about access to justice, comes in the form of large class actions, large commercial transactions where a litigation funder will invest money in the case and cover the cost of the lawyer. But it also comes in the contingency fees that we talked about from the US, and also in the form of insurance policies that are very prevalent in mainland Europe, particularly in Germany and Austria, France and Netherlands, where clients purchase this cover and then use it in the event of a piece of litigation. I know, for instance, one of the class actions there, Dieselgate, I think, or VW, that everyone knows of, the Swiss legal expenses insurers ran that as a group action where they paid all the fees. So basically all their policy holders were brought together and they ran the action. I mean, partly a reaction to the insurers seeing that all their policies were going to get used. So there was a money-saving element to it as well. But we see litigation funding developing from maybe a different perspective as the insurers, and we've seen the huge growth in particularly the Australian and UK markets over the past 10 years. And also the Canadian markets are now starting to grow as well. And everyone has a different aspect. And the aspects of each of these markets, and the US as well, are developing new law, developing new precedents in cases that are framing how this is going to work going forward. In the Australian market, for instance, at the moment, a settlement is approved after the settlement's made, and that would include whether the funder is taking a reasonable amount out of the case, whether the insurance premium is reasonable, whether the settlement itself gives all the claimants a fair outcome. In the Canadian market, the funding agreement and the terms of the lawyer's fees will be decided before the case even begins to run. And so these are developing areas, and each legislative body is looking to others to see how these things move on. From our point of view as an insurer, yes, we like to see cases presented well. We also have our different view between standalone cases and portfolio cases. And I think everyone's picked up on this point about a portfolio. If it's everything in, does that include bad and good? I mean, our view is that funders very rarely look for a couple of bad cases to put in with their good ones. So we're normally happy that if we work with a funder and we're happy with that funder, or if we work with a lawyer and we think that lawyer understands what they're doing, then there isn't going to be a couple of bad cases just to see if they'll work. That sort of thing shouldn't exist. But we also all have to be very cautious as the litigation funding market develops, that there is only a certain amount of good cases. And there's only a certain amount of cases that can be funded, and some people that come into the market won't find those cases. But I think, Philip, you made a point about a funder turning up and saying, I have 500 million to invest. Sounds great, but of course that money comes with a cost and a time where they have to invest it. Because professional litigation funders will generally have their funds when they start from major finance houses, and they're happy to provide those funds, provided that some money's paid back bit by bit by bit. So there's an encouragement to invest the funds. So, and I think that all the funders here today have built models on the basis of taking smaller investments and building up experience, and it's worked really well, and that's why they've been around for a while. From our point of view, as an insurer, it just continues to be an exciting and dynamic market, and it does provide access to justice. Yes, it will provide a level of upset to defendant insurers and some defendant firms, but it doesn't, I don't think, create spurious litigation. It simply facilitates litigation that otherwise would never be allowed to progress, and so in that way gives a better outcome for the consumer.
Thank you. I have some questions for you.
Excellent. I like this bit.
So I understand, we understand that insuring a case, a litigation, is different to funding with a litigation fund.
We don't get paid as much for a start.
So my questions were, is it easier to insure a case rather than if you compare it with a litigation fund?
In some ways, when the funder brings the case to you, they should have done a lot of work on it already. Okay. So if the funder's bringing the case, yes. But it's also much harder to tell or to ask a funder a question where they truly believe that everything about this case is already perfect.
Good. Thank you. Eduardo. Last but not least. Eduardo is going to talk about the lawyer's perspective. So Eduardo, thank you for your words.
Okay, first of all, I would like to thank you all here for being present here. I'm a partner at Cremades&Calvo-Sotelo, who you know that has had a very important role in the organization of this Congress. Probably the success of the Congress is so for you who have been attending to it. Well, litigation funding is something, as has already been said here, relatively new to Spain. I think that the first time Spanish law firms were engaged in the litigation funding and knew about it was in connection with the arbitration cases that were brought about against the Spanish kingdom, the Kingdom of Spain, for the change in the rules regulating the renewable energies. Those affected foreign investors. Those cases were brought about in accordance with basically with the Spanish treaties to the protection of foreign investments, and therefore not Spanish companies were involved in them. I only started to hear about litigation funding in about the month of June, when our firm was aware that we had some important cases affecting minority shareholders that had been suffered great losses because of the scandals in the banking sectors. That's when I started to learn about litigation funding. I started to contact litigation funds, and I was immediately aware of the importance that litigation funding was to permit the access to large litigation when large amounts of money was at risk. I think the main advantages of litigation funding has already been commented here, but I would like to point to one thing that we are seeing in one of our clients, especially larger corporate clients that made huge investments during the real estate
Boom.
how do you boom? That's right. Yes. Who made large investments that lost millions of euros, and one of the things that they very often ask us: what happens if we lose the money? How much will be the court cost we will have to pay? And many of these large corporations do not dare start litigation in cases where the result is not 100% clear because of this fact. That's why I think insurance can play here a big one can here be very important to so that they rely at least in that their losses will not be very hugely increased. Litigation funding, on the other hand, has not been regulated in Spain. It is new. It is based only in the general principles that you can agree on whatever terms and conditions you can agree in a given contract. Therefore, it is not regulated. This gives an enormous freedom in the way the agreements with the litigators can be agreed. Spanish law, as you probably know, Article 2 of the Civil Code permit to agree on any clauses, provided they are not against law. I said that a law specific for litigation funding does not exist, or contrary to morals. In this respect, I think this has to do with questions of deontology and ethics, which is whether or not if you obtain the funding for a given litigation, should you disclose this fact to your client or not? I think in some cases it's good to do it because some clients perhaps believe you are too generous, not charging them upfront any fees, when really there is someone behind you which is really taking the cost of the litigation. And then the third limitation is that they cannot be contrary to public order, which I think that litigation in any case is cannot be considered as against public order. Well, and since I think we are already very late, I think I will stop here. Thank you very much again for coming.
Thank you, Eduardo. I think that for non-Spanish lawyers in the audience, it's important to, we've discussed this all around, something important from a Spanish perspective. In Spain, you cannot obtain security for costs. If you tell this to a common law lawyer, it's like surprising, but in Spain, the cost issue is important because from a wealthy company, an entity which nowadays is facing high, massive claims from, in theory, not wealthy parties, the risk of winning a claim and not being able to recover the costs is a point to bear in mind. So in Spain, there's no security for costs. Okay, thank you very much. I think that we're doing well on timing. We can go to the audience to ask for questions. We have some questions arranged beforehand, so I will go through my list and see if they're present. João Callado?
Yeah, that's me.
João, you can pick up the mic.
I didn't know we had some questions arranged, but
so you have to ask the question.
Buenos dias.
Buenos dias.
My name is João Caiado Guerreiro. I'm the managing partner of Caiado Guerreiro in Portugal. And I've been listening very attentively to what you were all saying, because in Portugal, litigation funding is a new thing. And though we have had several conversations with the litigation funders for cases, and we're a business law firm, but we have a quite vibrant litigation sector. What we found out, maybe because it's new to the jurisdiction, is that the process of getting litigation funding is rather difficult and complicated. And in the end, it means that it's just better for us as a firm to invest than to spend all that time to get the funding. And this is, the challenge I would like to leave to the people who are doing the funding is we understand you're investing investors' money. We understand that you have bona fides duties towards them. But on the other hand, it seems, at least maybe because it's the jurisdiction is new, courts are very unpredictable. But I find that everywhere I talk about litigation, that it's rather complicated to get the funding. And either you're talking about very significant amounts, and then, yes, it certainly justifies talking to you, or if it's for one or two individual claimants or small claims, it's probably not worthwhile. We've also talked with, we've also looked for financing for some companies who had claims that they didn't want to pursue on their own for several reasons. And we found it a bit easier, but in the end we never closed. So maybe you could make some comment on how we can speed up this process. For instance, many the litigation funders we talked to, we had to provide the documents via email and so on and so forth. And this is just an example. It would be a lot simpler if we could do like due diligence, just get them on a website and you would check whatever you wanted to. And that's my main comment and question and challenge.
I think that's a fair comment, and I understand.
Thank you.
You share Philip's concerns. What you've mentioned, I have suffered it on my own. I mean, it's true that when you're working on a case and you started the case and you're working on it, and then sometimes a fund comes into the scene and starts asking questions and more questions and more questions, and you have to deal with the question and you have to deal with the case. So sometimes it's really difficult, and you get frustrated and you say, well, are you going to fund me or not? Because I have to deal with the work. So, Antonio, Ignacio, Diego, Simon, even if Joao hasn't made an express question, I think that you have to answer this concern.
Well, first of all, it is true that I think it's a challenge for all of us who are working as an investment officer there in the litigation funding industry, that we have to be quicker than we are nowadays. This is a clear challenge. But second of all, I would like to emphasize that we are the first one who really like to know if the case is good enough to be funded. We are the first stakeholder in the table willing to see if it is worthwhile to spend a single minute on that. So at least in my experience, I always try to not to waste my time, neither the time from the guy who is in front of me. And if the case that doesn't fit in our angle, I will try to reject it or just to tell it as soon as possible. There will be for sure. But as Javier has said, the Q&A process or the due diligence process may be time consuming, but for both parties, unfortunately. But this is what it is. I mean, as Antonio said before, we have to take care of the money of our investors, and this is what we are paid for.
It's not a charity. It's a business.
Exactly.
Thank you, Ignacio, and thank you, Joao. I would say that the answer to your questions or concerns was pretty much in the question itself. As Ignacio said, we have a duty to our investors, and our task is to deploy the capital of our investors. So that's the answer to the question of size and the question of due diligence and timing. Question to size is pretty much driven by our need to deploy a certain amount of capital in a very limited time frame with very limited human resources. So we would rather invest in 3 huge cases rather in 1,000 small cases, for the only reason that there is no capillarity enough in our industry to get and reach and manage and analyze every single case. That will change with time, and minimum amounts, if there are any, will increasingly become lower. In terms of due diligence, well, I found there is a huge difference when I am dealing with a litigation lawyer. I'm a litigation lawyer myself, but there's a huge difference when I'm dealing with a litigation lawyer and when I'm dealing with a transactional lawyer. Litigation lawyers are not used to due diligence processes. Our due diligence process of a legal asset would be not surprising at all for an M&A lawyer. They're used for a 3-month period due diligence with tons of Q&A questions and really picky and bothersome requests for information. So I would say we all, as litigation lawyers, would need to slightly change our mindset when we are dealing with litigation funders, because it's much more a transactional mindset what you need in dealing with them rather than a litigation lawyer mindset.
Can I add something?
Of course.
You know, I've been on both sides, as I mentioned before, but from my experience, when you're dealing with a funder, the first time can be very tedious, but the second time, they obviously analyze the risk as well with the law firm, and when you come to them for a second time, the process is more quicker, and as I mentioned, once again, they have funder over there now, they adapt themselves on the reality of the market, and they are very more quicker on the analyze. So is to once again to shop well with your funder.
Thank you. I think that Antonio's, going back to Antonio's 2 points there. One for me, litigators, we have to be more patient. This is for me. And 2, and this I don't think this has come up, the session. Funds come into can get involved at the beginning before the case has started, and also when the case is ongoing. So I think it's important to note. Okay, Christian Verbich? Not here. Okay, Christina von Ehren.
So do I have to ask a question or do you make a statement? Well, I am a German and Spanish lawyer with a base in Germany. And in Germany, just to speak in general terms, we have since 1998 a company that dedicates litigation funding. That was Forest, the first one. Now there are 18 companies, and it's a growing market, apparently. And on the other side, proceedings are reducing. We have less proceedings than 20 years before. So it's an interesting thing just to think about, because obviously many plaintiffs are interested in litigation funding or have a need to proceed like this, because companies, they don't have this liquidity problem. It's the litigation funding company who controls the whole proceedings, because in Germany nobody moves a finger until you hardly paid half or the whole amount of the cost and the risk when you lose the case. So just give you a figure: if you claim 100,000 euro, the risk if you lose the case is about 46,000 euro. If it's about 500,000 euro to claim, your risk is about 110,000 euro. That's a large amount. So it's quite interesting to have this company who is assuming all this risk of the proceedings. And there are usually, as I understood, 3 requirements the company proves before accepting a case, accepting to give the money for the case. That is, always they prove the value of the claim, must be a minimum of 100,000 because lower it's not of interest. There are some more smaller companies now having less amount of claims. And then, of course, they prove the legal opportunity to win the case. And that is a really close contact between attorney who is doing the case and the company, because the company does not have any interest in losing. So before it starts, they really are always in contact. But it's not so complicated, as Philip told, that there isn't any opportunity or just 5% of cases to accept. Otherwise, there wouldn't be so many companies doing litigation funding. And the last thing, and the most important thing for the company, is they check the solvency of the counterpart, because otherwise it does not make any sense. So maybe it is different in your countries, that these 3 requirements are the guarantee to have a successful relationship in between attorney, plaintiff, and the company. So that's it.
Simon?
The first point you made about the adverse cost or loser pays environment in Germany, I actually find that mildly attractive by comparison to the UK one, where it gets made up more or less as people go along. So it's fixing that cost.
But it's quite expensive.
It's not necessarily that. I mean, because of the scale, it's quite expensive on the lower value claims, but as the scale goes up.
Yeah.
This scale is not an invention, but it's on our proceeding laws. We have this official, it's not like in Spain, the lista orientativa or something like this. We have
good accent,
fixed quotes, and you look what's the amount to claim. Look at the tabla, and you see it's completely transparent, completely. What the attorney owns for the plaintiff, the counterpart attorney, the court costs are an important thing, because in Spain the court is gratis, isn't it? You don't have
free of charge.
It's free of charge, yeah. And in Germany, it's an important amount to pay before they open the file.
It's not always free of charge, but there's a small amount that companies have to pay.
No, in Germany, that's an interesting amount. And then you have to pay the experts, and also the expenses of the witnesses. So, and it's all completely transparent. You can see it before starting the file, what at the end will be the amount to pay to the counterpart, to the,
And do you have security for costs in Germany?
Yes.
Can you obtain the counterparty to post a bond, for example, to recover the costs if they lose the case?
No.
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 So, but the point is, from an insurance point of view, so we have a few cases in the German market, and the advantage is that the costs are set at the outset. Now, whether that level is deemed to be medium, high, whatever it is, it's set at the outset. To take an example of the VW case, which is, again, using that example, where we had insurers involved, we know what the adverse cost exposure is now. If you look back to the UK market, there's a case that everyone remembers, the RBS action, which started in earnest in 2011. By the time it got to its various trials, the opponent lawyers were saying their costs were going to be 120, 130 million. and they'd started off with sort of 10, 15 million. So that's one of the advantages, is control. And from an insurance point of view, and I think from a funder's point of view as well, if you know all the parameters at the outset, and then you're effectively then working on your win-loss, am I going to win this, am I going to lose this, it's a huge advantage. In terms of the funding of small cases, something we didn't mention is that there's various levels of funding. We've been talking a lot about the huge cases, the class actions, but then there's various levels of funding smaller commercial actions, and also down to some of the crowdfunding, where people are now investing very small amounts of money into the smaller cases to build up. And the returns on those are much lower for the funding, for the investors involved. But then also, as the funding market, I think Nashia mentioned it as well, as it expands, as there's more players, the commercial terms will become more advantageous to the people borrowing the money, because they have to be.
Thank you, Christina. Is Hakim Boulis here? Hakim.
Good morning, ladies and gentlemen. I have to thank you to be here with you. And I have to thank my friend Javier Cremades, who invited me to this Congress. And to talk about litigation funding, maybe we have to make a definition of litigation funding. What is the litigation funding?
Who wants to take the easy or tough question, or what is? It's the good part of being the moderator. I can.
Hi, Hashem, that's a very good question.
But because
that's
I have the answer, but I have to hear the answer from another.
I think litigation funding is everything where someone puts its work, it believes, in a case. So I think it starts much earlier than it hits the grounds of professional litigation funders. It was also mentioned you have, as a lawyer, to invest a lot of your experience in a case. You are the first one who sees your client. So you are the first one who analyzes if a case has a potential to get further to a litigation fund, who, as we mentioned today many times, are not picking up any cases. Why should they? They are picking up those where they can earn money. And so I think the first line of defense, when you want to call it like this, is litigation funding starts when the telephone rings and the new client is on the phone and tells you as his lawyer, the case. That's my opinion.
But it's not the way to put the legal terms on their way for ending, good ending, the litigation funding, to make the balance of the legal affairs a real balance.
I think we discussed this earlier. You came too late, so
maybe.
And I saw you. That's your downside on this. So I mentioned this in my comment. I think it's what litigation funding is doing is filling a gap, and it's a more secure way that people who can't afford to litigate are able to litigate. And unfortunately, it's not the whole portfolio of cases that fits for that. But it's a starting point, and I think an important one.
And
so
I would add,
it gives a balance.
And I would add, Eric, it's not only people who cannot afford, it's also people who do not want to litigate.
Correct. I think this is something when it comes to corporations, what was mentioned today earlier. We should not forget that CEOs, directors of companies have a compliance rule that if a claim is a valid one, they need to go after it. They can't just waive it. So some don't want. And to be honest, and I've done this on consumer sides, I like much more to work with corporations, because when you're building a claim and you have like one point of contact, and they have a bunch of, or an amount of a huge claim, it's much easier to organize. And of course, this is also better for the funder because it's less effort, it's less hassle. So yeah, cooperations is a very big part of it.
It's not part of their business to litigate. Companies see that it's not part of their business. They just want to keep on with their business and give the litigation.
Maybe they are looking for a third party who finance.
Maybe.
Also.
It depends. Okay.
Okay. Thank you.
Thank you very much. Anna Butch.
Hello, well, thank you very much for inviting me here today. My name is Anna Buch, and I'm a partner at Devonshire Solicitors, and I work in London. So I would just like to echo my experience. My personal experience is very similar to that of Philip and my colleague from Portugal, is that it is extremely difficult to obtain litigation funding. And the amount of expense you have to go through in the beginning of the case, and the amount of even counsel fees, expert fees that you have to pay in the very beginning, which are non-recoverable quite often, make it extremely difficult to obtain funding. On the other hand, I do agree with Eric and with you as well that it is a very important tool, and it gives access to justice to those who can't afford it or don't normally want to litigate, and it brings important cases to the courts. However, I guess my question to the whole panel would be, do you think that, well, like my colleagues from the UK already said, that in the UK, for instance, it is self-regulated. There is no real regulation of litigation funding. It is all. And even the self-regulation is really voluntary, that not all funders have to be members of the Association of Litigation Funders. Whether you think there should be more regulation, and whether you think there should be, that funders should work with policymakers, work further with policymakers to bring in more litigation funding regulation, because quite often, again, it depends on the funders. The involvement that they have in the case, and also the way that it affects the client-lawyer relationship. Genevieve mentioned that she doesn't believe it's a problem because obviously lawyers have to follow rules, and we're in England we are bound by the Solicitor's Code of Conduct. However, in practice, lawyers follow those who pay them quite often, and it is, I think, it can become a problem, and it is in some cases a problem where funders' interests conflict with those of our clients, and perhaps there should be further regulation. Thank you.
Dio, your turn to answer.
I don't have a clear answer for your question, but the purpose of any regulation is regulation for what? What do we want to regulate? We want to regulate how the people manage their investments? That is very difficult. That is very difficult. For example, in Spain, we have the justicia gratuita, what it's called. So any people that doesn't have money to reach to the justice, the state pays for it. So that's covered by the state. So regulate for what? Maybe I think the relationship between the fund and their clients, that shall not be regulated. Other thing may be the consequences of the third-party funding with the judge or maybe the tribunal, the arbitrators. And maybe more for the arbitrator than for the ordinary tribunal of justice, because that is perfectly regulated, and the problems comes up with the arbitrators. Arbitrators is different because that comes when you appoint an arbitrator, and an arbitrator wants to accept the appointment, he has to or she has to go through a check conflict list, and he or she may not, if he has a conflict problem, if there is a financing fund behind the problem. And I may tell you a little lawyer tale, because it comes from my experience. I was in an arbitration, an investment arbitration, and I was leading a cross-examination of a witness. And I was seeing something strange in that witness. And I did something that a lawyer never have to do. I asked a question that I didn't know the answer. And I asked him if he has a litigation funding behind him. And he answered me, and he told me, yes, of course. And you are not able to imagine the problem I generate in the tribunal. I generate an earthquake. The claimant, the counsel for claimant starts to raise objection like a machine gun. The president of the tribunal look at me like he wants to kill me, because there is a real conflict problem when there is a third-party funding. That may be regulated, but the other side of the financial funding, I believe that it shall not be regulated. Thank you. I don't know if I answer your question.
Okay, thank you. Jesseren? No. And last, Jacopo Destri.
Hello, good morning. I'm the last, the last one. I'm Jacopo Destri from Italy, and I'm very enthusiastic about the topic. I have a list of questions, but I'm gonna ask everything. The first one was related to the regulations versus the regulation. But first of all, what I understood from today's interesting panel is that third-party litigation funds are not philanthropic associations. So this is very important to be understood, because this goes to the assessment of risk and the return of their investment. I've heard about a software tool which have been developed by a firm, I will not make the name, which is able to assess the risk of a litigation. I think this might be useful in the due diligence phase, but the real question is, that tool can, replace the sensitiveness, the feeling of a lawyer about a case. And the other question is, funds, in my impression, are going through maths, engineering, but the law is not an exact science. You cannot predict what's going to happen in a case. There are many parts of this equation which can vary case by case, depending by the judge, by the witnesses. So you cannot keep everything under control. So what I expect from third-party litigation funds is an act of faith in the law. I know this point is very critical. I'm agnostic, so I'm not doing this because I'm. But it's a problem of understanding what you have in front of you. So you can regulate or not regulate. I'm in favor of a regulation because, honestly, there are many issues that could clarify the role of the third-party litigation fund. For example, in Italy, the assignment of the claim before the starting of the litigation, without mentioning that assignment in the litigation, just for warranty purposes, as I have seen in several contracts, can lead to a rebuttal of the case on the merit, because the party acting is not the right holder. So if you want to secure your claim, you don't have in certain jurisdiction to use that kind of clauses. So for sure you have to make an assessment case by case, nation by nation, to understand if your clauses of the litigation funds are to a certain extent in conflict with public law in that country. And in Italy, I can say that litigation funding is allowed, but with some, boundaries. So I will make a question. The first one is, are you willing to recover cost with a 100% security ratio, or you are willing to invest and you know that probably there is a percentage of risk that you can easily access? Because the real point is, if I want to litigate a case like the Schrems case, do you know about the Schrems case? Maximilian Schrems is a guy who was started a fight against Facebook. And this is a case of class action. The third-party litigation fund probably has lost its money because the case has been assessed by the European Court of Justice, and it has assessed that the assignment of consumer case to a third-party litigation fund cannot be allowed. So you lose the role of a consumer in that case. So the question is, there is a risk. What's the level of risk that you are willing to take on the fund? And which kind of litigation you take? Because the costs, for example, in Italy, are very low for the access to justice. So you don't need to spend all the amount for this due diligence process to get, just because the risk is very limited. The cost that you can be condemned to pay to the counterparty are very limited. The cost of lawyers are limited in respect to English courts. So please, keep in mind that there are other jurisdictions which are very interesting, where the length of litigation is an old tale, because, for example, in Italy, there are specialized courts for enterprises, and they are doing very well as compared to other European countries. And, for example, now we are introducing a new class action, which is based on the opt-in principle. On the opt-out principle, as the US. So there are things moving forward. For example, the GDPR is providing a new opportunity if you look to Article 80. So you are not a philanthropic association, you look to business, and I think that you can look to business or big cases, which are very interesting, like the Shrem case, or portfolio cases, where you have a limited amount of time to dedicate to due diligence, but in the overall process you can get, more money, because you temper the risk in differentiating your investment. That's it.
Thank you.
Just a few words from a claimant lawyer. I heard you say an act of faith. Well, I've never come across a litigation funder that will fund anything on any form of, any form of act of faith. These are hard-nosed business people who want a substantial return on their investment, and will look very carefully at the case. And as I've said, if there are too many unknowns there, they'll just walk away, and they won't fund, and no act of faith is going to be good enough on their behalf. They'll also look at every case in every different jurisdiction about whether they'll fund in that jurisdiction. Without causing a diplomatic incident, I would imagine that a number of London-based litigation funders won't fund in Italy at all, after what we call the Italian torpedo, whereby the Italian courts used to be able to take jurisdiction on the matter, even though another court was expressed in a jurisdictional clause, although that's by the by now. But I well imagine that a number of London-based funds will not invest in a case through the Italian courts.
Thank you. David, you want to say something?
Well, we're in the U.S. jurisdiction, where access to the courts isn't very expensive relatively, and there's no cost shifting if you lose. I think the funding dynamic is a little bit different. I wouldn't call it faith, but there's also an inherent risk in litigation, and I think funders understand that. There are going to be unknowns with the judges, changes in the law with the witnesses. I think that's a fantastic point, and I do see that for that reason, funders will be more willing to fund a portfolio of cases, because they can lose one or two. And I can tell you from experience, at least being a contingency fee lawyer, we have a bunch of cases. We're not going to know which ones are going to lose. Some of the best cases I've ever brought have lost, and some of the worst cases I've ever brought have won. And I'm not going to be able to tell you ex ante which one is going to be the winner. And I think funders, if they don't understand that in the U.S., then they've got some educating for themselves to do.
Thank you. Does anybody else have a question from the audience?
I just wanted to comment on Professor Shrem's case. He's actually, as I understand, using group funding and GoFundMe and things like that, and he's getting millions of euros from average citizens to fund his newfound love for litigation. I think the interesting thing about, if folks are going to fund that litigation corporately, is how much of the fines will go back to the plaintiffs, and how much are the states going to keep, and nation states going to keep. I mean, the fines are so big, there's plenty to go around, but it's just curious to see how those are going to divide up before I think some of the funders would want to actually fund GDPR litigation.
There was a question over there. Do you mind giving her the microphone?
Hi, Carmen Pombo from, I run a Rule of Law Foundation, and I also chair the International Bar Association Rule of Law Forum. I would like to thank you for this amazing, eminent group of panelists and how you've been enlightening us on this topic, which is really showing like the future of the legal industry and how this is something that is happening and that is happening all over the world now. Because my field is human rights law, and I work with colleagues who are doing human rights litigation and strategic litigations on human rights, we've been having lots of philanthropic funds actually funding lots of human rights cases, so third-party funding for a long time. And I was just wondering, of course I was listening to you, and what was the business case for the lawyers, what was the business case for the funders, and always referring to the philanthropic case as something really negative. So here, and with much admiration to everything you've said and the way you've approached the case and how this is something very professional, how this is transforming the legal industry, I would really like to focus, and because we're in this World Law Congress, and because the theme is peace through law, whether you could have a comment on access to justice for the most vulnerable in connection with strategic litigation and philanthropic funds as well, whether you had some insights in connection to this, please.
Thank you. And Antonio, Pastor?
So you left me with the toughest question, that's for sure. Thank you very much, Carmen. No, not at all, not at all, not at all. I tried to refer a few minutes ago to the fact that justice is not all about commercial litigation. We in Colonius and most of the litigation funders I know or I've worked with are focused on commercial litigation because there are, in the world of justice, there are things that are much more important than commercial litigation, which is precisely some of the topics you were talking about. When somebody asks about having a definition of litigation funding, I have my own definition for it, and this is just a personal view. I would say litigation funding is taking an interest in someone else's claim for profit. And let's be realistic, the industry is for profit in this particular case. That's precisely the reason why we at Colonius only do commercial litigation, because there are topics in justice we believe should not be driven by profit. If we are, or if we were to fund or provide funding to that kind of proceedings, which directly affects the core of justice, we won't be seeking for profits. If we do that, we won't do it because we want a profit. That's not an area in which profits are important at all. I'm referring to economic profits, obviously. There are a bunch of other profits, but financial profits, we would never, I don't know how to say it in English, but in Spanish, no nos atreveríamos a hacer negocio nunca con litigios que afectan directamente a los derechos humanos. Eso no quiere decir que no fuéramos a intervenir. I'm sorry, but it's easier for me in Spanish. Eso no quiere decir que no fuéramos a colaborar en el desarrollo de la justicia en los aspectos más sensibles que son esos. Estaríamos encantados de hacerlo, pero nunca jamás por beneficio, nunca jamás persiguiendo un beneficio nuestro ni de nuestros inversores. Y si alguna vez alguno de nuestros inversores lo pretendiera, seguro que puedo encontrar otros gestores de fondos que lo hagan. Nosotros no lo haríamos nunca. No, ese tipo de decisiones no pueden tomarse con modelos en Excel financieros sobre qué da más o menos euros. Hay muchos fondos de impacto social. Probablemente los haya. Lo que pasa es que nosotros no somos unos de esos. Sí que hemos hablado muchas veces en los foros propios de la industria de cómo colaborar en ese tipo de casos, pero siempre desde la óptica de no hacerlo, desde el punto de vista y no voy a decir no profesional, sino que tiene que hacerse desde un punto de vista profesional, pero hacerlo profesionalmente no implica buscar un beneficio. Se puede ser profesional de la filantropía. Por desgracia nosotros no lo somos ahora mismo. También es verdad que es una industria que lleva muy poco tiempo y que aunque pueda costar creerlo, los gestores de los fondos soportamos mucha presión de nuestros inversores, que a su vez soportan presión de quien ha puesto el dinero y que es al final quien tiene la última palabra respecto de a qué se dedica y a qué te permiten dedicarlo.
Thank you, Antonio. We're running out of time, and there was a question here.
Sorry, just a very quick comment. 1 second. We have in the last two funds we have raised, we have allocated a small amount in comparison with the total amount of funds, but it is still a significant amount of money for non-profitable cases, which means that we are not expecting in those cases any kind of return.
Thank you.
I just wanted to just add one comment. I share your view that not a lot of third-party funders are financing human rights cases, but some, like Terium, for example, IMF, Bentham, and Woods for Litigation Funding, have fund to finance human rights cases on a pro bono basis. And as we realize as a firm, now I'm back in a firm, that they have a lack on the market as to fund human rights cases. We have decided as well to fund ourselves human rights cases. So at the moment we have a lot, my firm called Osfeld, a lot of human rights cases funded by ourselves, like the free period cases, mining, on the mining industry as well. But you need to look around because there are funders out there that they found human rights cases.
Thank you, Genevieve. One last question.
Well, it's only a comment. I'm completely outsider because I work for a charity organization and we have no funds to defend these human rights causes. But I think sometimes we have there is some economic return who could be a possibility for a fund return. There is no clarifier or to identify. Maybe we can work together to open mind about the litigation funds. I understand perfectly if you risk something with your lawyers and you need economic profit. But there is also human rights causes who have economic return. For example, when you litigate with against the state, there is a lot of economic return. Of course, there is a risk, another risk sometimes law firms can't accept or try in Spain, because when you are against the state, maybe you are also against your client sometimes. So I suppose this is the question, but thank you very much because I'm completely outsider and I was very disappointed. I learned a lot, but now I think there is a very, very small possibility to continue to talk, so thank you.
Simon, do you want to close? I just wanted to say, we've talked about litigation funding, which is a tiny part of third-party litigation, third-party funding. It's a little piece of a third party. I'm being told off. Shall we? Well, thank you very much. It's been a very interesting session. We had 2 hours. I thought we wouldn't make it, but there's still some more questions to follow up. So happy for any of us to follow up our questions. Thank you.
so good day.